So, hi everyone. Today's session is Unit 8, which is Law of Accounting. Is everyone on the right session?
Yes.
Yes? Okay. And the learning outcome you're going to do today is learning outcome 1. So, firstly, just to give you a little bit of background into the unit, it's actually to look at the elements of affecting things like businesses and things like that. Okay, if you have any questions, please ask whilst we're doing the session. And also, if you have any sort of, if you're confused or if you need something reiterating or explaining, please ask me. Okay, my name's Shazia Khan. Okay, so I'll be teaching you the units from now on. So there's 4 learning outcomes, and then there's an assignment discussion session, which we'll be looking at the assignment in more detail, so you've got a better idea of what to do with the assignment. So the unit aim is to develop an understanding of English law impact and how it impacts on businesses and other accountancy practices. Why is it important to look at the law around businesses and accountancy practices? Why do you think it's so important? Irene, why do you think law is so important when you are working in a practice or you are working in a business organization? Why do you think law is so important?
Law is important because it's sort of lets everyone, both parties, all parties, be aware of their rights and their responsibilities and their duties.
Yeah.
In a business environment or in any
Yeah.
transaction. So it's important for all parties to know legally what their rights, responsibilities, and benefits,
Yes.
what the rewards
and that they're following policies as well. You know, they're following the policies in place, they're following the laws, the regulations, like you said, the rules. You know, you must be there to follow things like a basic example would be things like if you're an employer, you should follow health and safety rules. You know, you should be there to follow that. Confidentiality is another really important element of it. So you as an employer or an employee have to follow policies and rules and regulations. Like Irene said, it's so important you follow this legislation. Otherwise, you're breaching it. So it's really hard to, you know, not follow the law because it's in place. So the indicative content for the session today is we're looking at contract law, and we look at things like how a contract is valid, how is it made. We look at principles of agency and the relationship with case law and tort law. So first we're going to start off with looking at the elements of law itself, and why there's private and public law, why we have private and public law. So when we talk about public law, and there are 2 different branches, and they may govern, you know, like society as a whole, but it's between individuals and entities. So public law is concerned with things like, you know, the relationship between individuals and the state, as well as the structure, powers of the government institution. So public law is primarily focused on the public interest. Things like constitutional law, which are things like, you know, what is constitutional law? When we look at constitutional law, what is what comes to mind firstly for you?
Company's house.
Sorry?
Company's house.
Yeah, okay. So it's a constitution, it's a branch of the government. Okay.
Correct, yeah.
What else?
Like HMRC, all of those things.
Yeah, yeah. So it deals with principles, structures, and the operation of a constitution. So it looks at the different branches of government. Then you've got things like administrative law within public law, and that looks at bodies, agencies, like you said, DWP, you know, HMRC, tribunals. It also looks at the fairness and procedures that are in place. And then within public law, you've got the final one is criminal law, which defines, you know, penalties and regulates like things like, you know, what punishment you get. You know, if you commit a crime, you should be concerned with getting some sort of punishment. Also, it looks at things like public safety, public orders, any sort of orders in place. Then you've got private law, and that is also known as a civil wrong. Okay, and it's the relationship between individuals, entities, and organizations. And it's concerned with rights, legal remedies, things like, you know, contract law, which it looks at. What could be an element in contract law for private law? So if you get a job, what would you get when you get the job? Would you just go to an employee, you'd have an interview, you'd get the job, what would they give you?
Contract, employment contract.
Excellent. Contract. Why would they give you a contract?
Yeah, they wanted to bind you with the rules and regulations.
They want to bind you, yes. They want to bind you with the rules, even if they're wrong, yes.
Yeah, that's right.
They want to bind you. They want to get this contract together, that you formed a contractual relationship with them. And in the contract, what does it define?
Terms and conditions.
Sorry?
The terms and conditions of the employment.
Yeah, yeah. But does it define what you have to do as well?
Yes.
Yes. So it's your right and obligations of the parties in the contractual agreement, okay? And who was it that said bind it? It's very interesting when you say they bind you as well into a contract, because it is quite, you're very right to say that. Then we have tort law. What can tort law include? What if you go to the doctors, or if you go to the hospital? Sorry, if you go to the hospital and you have an operation and something goes wrong, is that a tort law? So if they're operating on you in the operating theatre and they've left a little swab, cotton swab in your stomach, and they've operated back and sewed you up, what have they done there? What do you think they've done? Are they negligent? Irene, anyone?
That's negligence, and
Yes.
that's
Yes.
negligence, and litigations can be taken against
Yes.
the authorities, which is NHS. Hence, we hear
Yes.
all the payments sometimes
Yeah.
that they've got to make to families for the
Yeah.
deaths of
And that,
patients in
Irene,
their
has
care.
happened a lot. There's lots of cases out there
Yeah.
that it does happen to. And you know, I've known people that have experienced that, you know, where they have left something in their stomach, and there's forms of negligence, you know, because it's a civil wrong. And then they have to take them to court, and obviously it's a case in negligence that they have to prove that they had something left in their stomach after the operation. It does happen a lot. You can be negligent in different forms, you know. If you, for example, if you're on a bus and you sit on the, you know, the seat of the bus and the seat breaks, the bus company is negligent for not protecting everything. So health and safety is a big part of it. The next element of private or civil law, as we refer to it, is property law. So that could be like the ownership of estates, personal belongings, your intellectual property. And then we have family law, which regulates things like child custody, marriage, adoption, and commercial law, which could be things like accountancy, banking law, company law. So, you know, there is a difference with it. You know, while we look at public law, which focuses on individuals and the state, private law primarily deals with the relationships between individuals and entities in civil matters. So both of them are, you know, branches that private and public that protect individuals' rights and regulate aspects of society. So, you know, there is a need to have, so these are the two types of laws. Key terminology when we look at what a contract is, and what the purpose of a contract is. So contract is it binding? When we look at a contract, can it be binding or is it binding? Nisa?
Yeah, it's contract is always, no, I don't think the contract is binding. It's the terms which you both agreed on, you know. So that's
Yeah, but
The
if it's a
contract is
contract
binding. It's
between,
binding.
it is binding, it's
It is
legally
binding. Once it's
binding.
been agreed by both parties,
Yes.
it's binding. Because
Yeah.
that's
yeah.
what
I mean, in terms of that, yes, yeah.
Yeah,
But
yeah.
I was going to say it's slightly different than the
No, say
employment
what you
contract.
wanted to say, yeah?
Yeah, no, I'm saying like it's different than the employment contract. So that's why I
Yeah.
said like it's not the way they bind, like employee binds.
Yes,
Between
yes.
contract is always like it's a mutually decided. You can always dictate the terms if something is not
Yeah,
in
you
good
could
side.
put your terms in as you want, but it
Correct,
is a
yes, yes.
legally binding
Legal,
contract.
yes, correct, yes. That is where it is correct.
Yeah.
Yeah, yeah.
It's a legally binding contract and it's enforceable by the law. And,
Correct.
it's a contractual agreement which has certain rights and obligations. And like you said, terms within a contract, you can change them terms around, to suit the contract you want it to be, and it's so important in everyday life. Contracts, are the second of every day for businesses. You get into a contract in new relationships, where you are trying to maybe trade. That's a contract in itself. So, it's a contract that is performed with regards to it. And, it is there to identify your obligations, what you must follow and how you must follow things. And there's lots of cases, that will fall within a contract where people haven't followed things. If you make an offer or if there's a promise and it hasn't been followed, are you breaching the contract?
Yeah, you will breach the
Yes,
contract if you don't
you
follow the
will.
process. Yeah.
Yeah, you will breach the contract. So it's really important. So there's 7 elements of a contract: consideration, an agreement, intention, legality, offer, acceptance. And examples of contracts which you mentioned as well is things like, employment contracts, lease agreements. Lease agreements. What could a lease agreement be for? What could you have a lease agreement for?
The number of I mean, you can have it for a property,
Yeah.
rented, or
Yeah.
buying the house.
What about like if you go into a shop and purchase something, or purchase a car? A car could be a lease agreement.
Correct. Yeah.
Yeah, so you've got insurance agreements, you've got financial agreements, and these are all elements of a contract. And it's so important that you must follow this because, any legally binding contract, like we said, this diagram identifies a contract in regards to what is, the elements of an agreement. So you have an agreement, you have an offer, which is what is offered to you. You have acceptance. Consideration can be in the form of money or the meeting of minds. Intention to create legal relations, and terms of a contract. Like you mentioned, the terms of a contract are really important as well because they identify any exclusion clauses, any sort of common rules. And if you breach the terms, if the terms are breached, you are awarded damages or any other remedies. So, it is really important that you follow the elements of a contract. Are they always followed though? Are elements of a contract always followed? Do people abide by contracts all the time?
No.
No, they don't. Why? Give me an example why they don't do it. Or give me an example of where it might happen.
It might happen whereby there are changes, the terms were not kept.
Yes.
So elements were not kept. So, things don't go as scheduled. The timing, the elements, the various elements of the contracts are not actually kept. So that affects the whole contracts.
So when we look at the 7 elements, going back to that diagram, it is really important that the 7 elements of the contract are identified for the contract to be legally binding. Now, if any of the elements are missing, is the contract void? Yeah, the contract is void. If any of the one or more of the elements are missing, then the contract could be void or unenforceable.
Yes.
Yeah, so that suggests that the parties that are in the contracts will not be held responsible for any sort of obligations within that contract. So it's really important that the 7 elements are part of the contract. Is everyone okay so far with contract part of it? Yeah?
Yes, yes.
Yeah. Okay, so now we're going to look at Trade Description Act. When we look at the Trade Description Act, what's the first thing that comes to mind? Trade description. What do you think comes to mind?
It's a business like agreement.
Yes. Yeah. It is an act that makes it an offence for any sort of businesses to sell a product or service based on misinformation. Why is that so important? Why can't you sell something with, you know, the information that's incorrect? Why do you think that's so important?
Because if anything goes wrong within the business, then who is responsible, you know?
Yeah.
That's why you need something in place, at least both buyer and seller.
Yes,
be
excellent.
safe.
Yeah.
Yeah.
So it's an example could be things like, you know, they can't, it's an offence for any sort of business to falsely describe something in regards to their product. So an example could be, you know, for example, if you're selling a car, Toyota's selling a car, and they, you know, give false information about the size of the engine of the car, will that fall under the Trade Descriptions Act? Because they are misinforming you, aren't they? So, you know, if they're misinforming you, that would be, you know, that would be come under the Trade Description Act, because the actual information they're giving you, if the engine is a 2.0 that they are advertising, but when you go and buy the engine, you bought the car, it's a 1.6. So are they giving you accurate information? Irene, what do you think? Or anyone else? Swagner?
Okay.
What do you think? Do you think if you're going to buy a car and the car is described as a 2.0 engine, and you buy the car thinking that it's a 2.0 engine, and when you go back, the car's, you've told it's a 1.6, is that false information? That's misleading, isn't it?
That's
Yes,
misleading. It's
Yes,
misleading.
it is,
Yeah,
yes.
you have the right to decline.
Yes, and
That's
that's breaching the Trade Description Act, isn't it?
Yes.
So it's misleading you and giving you false information. Okay, so that is why it's important. Is there a need to have this Trade Discrimination Act?
Yes.
Why is there a need to have it in today's society?
Because of lots of misinformation and
Yes, yes, excellent.
you know,
There's a lot of misinformation going around, and you need the act will be there to protect you as an individual. You know, you need that protection. You can't just expect, you know, people to give you false information. The next one we have is Unfair Terms in Consumer Contracts Regulations 1999. And this aim is it's an aim to protect consumers, so it could be you or me, against any sort of unfair standards in standard term contracts. So, for example, you know, if you're as a trader, you can tell that very few consumers are aware of any sort of regulations. And the regulations are policed by the Office of Fair Trading. What's the Office of Fair Trading? It's like a police force of trading standards. And what do you think they do, Office of Fair Trading?
I think they ensure compliance and
Yes.
Among traders and the consumers.
Yeah.
So they monitor the regulations, ensuring that quality of No, they
Yeah,
don't
that
have-
people are not selling, you know, another example I'll give you is counterfeit clothes. Okay.
Yeah, yeah, yeah.
A famous part of Manchester, Cheetham Hill, probably a lot of people know, they sell a lot of counterfeit products, okay? Things like, you know, maybe tracksuits that are Nike or advertised as being, you know, they are fake products, okay? The Office of Fair Trading has, you know, trading standards has a lot to do with that because there's lots of raids every time, and they come in and they police it, and then they confiscate everything. Okay, and that in itself is where the Office of Fair Trading is used, you know, and you know it could be like, you know, other things like, you know, a consumer is, you know, selling stuff. Sorry, because a seller is selling stuff that's out of the regulations of trading standards. You know, and they have to follow the unfair test. Examples of unfair contracts could be terms that allow the trader to unilaterally change the characteristics of the goods without good reason. So changing how the good looks, you know, whether there's enough, you know, the standard term, you know, is expressed with language that the other person understands. And you know, it's mainly there to protect individuals and consumers' rights. And there is a need to have it because, you know, we live in a society where things happen, you know, and things happen which are unfair and people don't follow the regulations. So, you know, people get into trouble for that as well. And, you know, it goes to court, and it is something that, you know, is all to do with trying to protect individuals' rights. 1.1, we go on to looking at the elements and nature of contractual agreements, you know, why they're so important. We've got the elements of a contract and why they're so binding, why there's a need for it. You know, it is a contract, as we said earlier, is a legally binding agreement between two or more parties. And to meet the contract, they must have the 7 elements. You know, it's really important that the elements are covered of a contract, because, you know, you need to make sure that the contract is it's not void, you know, it's a contract that can be enforced in court. And, you know, some people breach contracts with the terms, as mentioned earlier, but it is literally a legal document that needs to be followed. You know, where if, for example, if someone provides you products that are deficient or they don't meet the regulations, you know, you don't have to pay for them products, and there would be a case in regards to a breach of contract. So as we mentioned, the contract law has developed over centuries, years and centuries, and judges use it, judges regulate it, and it reduces any sort of conflicts with businesses. As we mentioned, components of a contract can be things like the formation, how it's formed, why it's so important, you know, that the contract is formed like this. The element preview of a contract, exactly who are the contractual obligations owed to, the construction, what kind of obligations are included in the contract, and the mitigating factors when the contract is void or voidable, the discharge of obligations, at what point are the parties free from their contractual obligations. So that's really important to identify the elements of a contract and why contract law is important in everyday society and life. There's a video here that we could watch in regards to what a contract is, which I'll just pause the. So as we've looked at, that video identifies, you know, what a contract is in regards to personal experience, but also in regards to elements of a contract. So the example they gave was the scooter bike, you know, where someone had sold the scooter bike but not got paid for it. So that's where the contract was void. It looked at the ingredients of a contract, the main ones being offer, acceptance and consideration, and how it's legally enforceable as well. So it just gave you a little bit of an idea what a contract was. So what is contract law? Why does it aim to do? Contract law aims to provide a legal framework And the law of contract is self-regulatory, and there's a need for it, isn't there? There's a need for us to have contract law within society. Why do you think there's a need for it? Why do you think contract law is so important? Nissa, why do you think contract law is so important? Jane.
It is because, like, you know, it's always to give safety to the both the party,
Yes.
and just to make sure like the things or business run smoothly.
Yeah.
There is
For
a rules.
example, if you're working in an accountancy firm, okay, and you have a contract with your client, what does that ensure?
Yeah, your fee safety. So
Yeah.
the work you're gonna do, and it will establish your like liability.
Yeah. And it establishes what level of work you can do. You know,
Correct.
you
Yeah,
don't,
yeah.
you know, because it's important, because some people become very greedy and they say you should do this extra and that extra. But if you have a contract in place that says, no, you shouldn't be doing this extra, then that agreement is a legally binding agreement, you know, between you and your client. So what's an
Correct.
agreement in law? It's the meeting of minds, and it's something that, you know, identifies, like we said, your rights and obligations. You know, an agreement needs to be put in place for lots of things, you know, as an employee, as an employer, but also, you know, outside services as well. You know, agreements need to be put in place for services, goods. So agreements are really important, and if they're breached and not followed, then you know, there is a void contract there. Examples of standard form contracts can include the ones that we tend to use quite a lot is unilateral ones and bilateral ones. Just 1 minute. Just 1 minute, sorry. Sorry, I just can't see the slides. Just go. Can you all see the slides there? Unilateral and bilateral one?
Yes.
Yeah? So unilateral contract is a contract where one party makes an express promise or undertakes a performance without first securing reciprocal agreement from the other party. So it could be regarded as a one-sided contract, and that could an example would be an insurance policy contract, which is partially unilateral. An example of a unilateral case is a really famous case called Carlisle and the Carbolic Smoke Bowl. Does anyone know about the case? I'll give you a couple of facts of the case, and it's a really famous case in regards to unilateral agreements. And in this case, the defendants advertised their balls curing for cold, so influenza. They would pay anyone £100 who contracted to use the ball 3 times daily for 2 weeks, according to the printed directions. And the defendant also added a passage that £1,000 is deposited with Alliance Bank, showing out sincerity in the matter. So plaintiff relied on it, but didn't work. Here, whether the important element was whether the plaintiff's performance was acceptable, and the court reckons that 100,000 is deposited with Alliance Bank, embodied that the defendant did make a promise. So there was a promise in this case, even though the performance of conditions is acceptance of an offer. So, you know, sometimes in unilateral contracts, it's quite difficult to identify, you know, elements of that. Then you've got the bilateral contract, which looks at a clearing trade or side trade, deals with an agreement between parties or states, aims to keep trade deficient. So this is an element where, you know, where you're trading with someone and what the elements are of the contract, because it's so important in regards to identifying that whether it's a unilateral contract or whether it's a bilateral contract. And the example, the agreement versus, and this chart here, this little table shows the difference between each one, and the difference between an agreement and a contract. When we talk about it, you know, agreement doesn't have to be in a writing, and neither does a contract. But when we talk about consideration is required, in agreement, the consideration is required, and in a contract, in an agreement, there's no consideration required, whereas in a contract, there is consideration. In an agreement, there has no legal effect, whereas a contract, as we mentioned, is a legally binding element. Does when we talk about legally binding, does it protect the individual as well? Why is it important to have a legally binding contract? Do you think it protects both parties?
Yes.
Why? Why do you think it protects both? You're right, Irene, but why do you think it protects both parties?
So if a remedy could be sought by both parties, if
Yes.
one party but one of the two don't keep the side of the contract, the obligations, then of course the contract in itself, you know, protects, because it can be enforced in law that, you know, remedy required is given to either party.
Yeah, so there needs to be, you know, it needs to be fairness for both parties, doesn't it?
Yes.
So this, as we mentioned, this is like the terms. So we looked at this diagram earlier, and this looks at the terms of a contract and the consideration, the agreement, the types of terms we've got, and it looks at the definition of what consideration is. So this element, this actually identifies the different types of terms, how it's breached, if there's any sort of elements of terms in place, and what are the intentions of the parties. Okay. Now we're going to go on to look at 1.2, and that looks at explaining the principles of agency and their impact on business practices. So the law of agency is really important when we look at the element of commercial contracts. You have a fiduciary duty that involves a person which is called an agent, and the agent is the person you've given the authority to act on behalf of the principal. So at the heart of any sort of agency relationship, in any sort of commercial contract, they form the skeleton and relationship. So the principals constitute the principal, the agent, their duties and obligations, and identifies, you know, that the agent is the one who is given the authority to act on behalf of the principal. And an example is if you consider a situation where a business wishes to expand its foreign market, they'd appoint an agent who's familiar with the local market, so that that agent is able to explain the, you know, help in regards to the expansion, and the business principal is the individual who's taxed with the expansion in that. So a number of key terms and concepts are essential. Terms and essential is an agent, again, employed by the principal. And then you've got the agency refers to the relationship between the principal and the agents. And the agency costs as well here are incurred by the principal. So the principal's duty is paying the agent. Their main duty is to pay the agent. Identify any sort of liabilities that arise, and look at cooperating with the agent in achieving their goals. The separation of ownership and control. So there has to be this differentiation between the elements of an agency and the principal. You know, they have to have that element of having these separate rules and separate duties in place. An example would be if a business, which is the principal, decides to expand into a new territory and hires an expert who's an agent, that agent must be there to, they agree the duty. So there's a contract in place there. So it goes from the principal, the shareholders, and the agency, and the main task there as well. Agency theory and corporate governance. So agency theory can help to explain the actions of various interest groups in the governance. And here you've got the companies owned and managed by the same people. You've got the expansion required investors, who are the shareholders, and the delegated running of the company in the diagram, and separation of goals. You then have the principal-agent relationships and why they're so important. Why do you think it's important that they have this relationship, the principal and the agent? Why do you think it's important to have this relationship with the principal and the agent? The shareholder is the separation, it needs to be in place, because you can have conflicts between principals and agents, and that would be things like, if the agreements are not put in place, whether the principal, ensures that the agents, they're doing their job properly, because, in some elements, they won't be doing their job properly as well. Prominent business scandals revealed between 1998 and 2008. So these are some scandals that occurred where there was violation between the principal and agent. There's a list there: CMS Energy, Elon, New Network Associates. So some examples there you can have a look at in your own time as well in regards to that. 1.3, explain the law of tort and remedies and elements of that. So when we look at law of tort, it identifies the issue around what law of tort is. And if anyone identifies it, what do you think when you talk about the law of tort? What do you think the law of tort means? What do you think the law of tort means? What is it? What is tort law? Is it a civil wrong? So tort law, as we mentioned, is a civil wrong, okay? And it identifies, that there must, for an element of a tort case to be successful, there must be a duty, a breach of duty, causation, and injury in place. Differences between contract law and tort law is that contract law is a consent-based relationship between parties, and tort law is concerned with a non-consensual relationship. A tort, as we mentioned, is a civil wrong, and it identifies that, elements of that is where someone suffers in that. So one party has caused harm to another party. Can you give me an example of tort law where one party has caused harm to another party?
Example is where there is an accident on the road,
Yes.
and one party is injured by result of the perhaps recklessness of the other driver.
Yeah. So the harm could cover things like, the pain. It could be payment, loss of income, property damage. Like you said, the good example is the element of where someone has a car accident, and the element of negligence by tort occurs there. So there are two options. You have limitation periods and you have the main elements of tort. And under the element is that you've got tort of negligence, defences, negligence by professionals, and tort of passing off. Now, negligence by professionals, what could that be? We mentioned a little bit on earlier, didn't we? Who's a professional that could be negligent? Nissa, could you mention Swapna or Jane?
One giving care, one responsible for providing professional care, for instance,
Yes.
lawyer, an accountant, A doctor, medical doctor.
Yeah, medical doctor. Yeah, it could be. It could be anyone that's a professional that's given you care or giving you sort of advice which has been negligent. Okay, so you know there are elements of tort which can be nuisance, where the tort allows a claimant to sue for what could nuisance be? What if you're causing a nuisance? What could it be you as a neighbor making a nuisance, you know, making noise and things like that? Could that be?
Yes, it's possible.
Yeah.
One can be
Private nuisance where landowners are possession of land. Public nuisance, so if you're causing any sort of issues in the local community, example, you know, the keeping of diseased animals or shooting. Trespass to land is a form of nuisance. You know, someone trespassing your land to get to the other part. Trespass to person as well. Trespass to person is another one where it could be things like assault, battery, false imprisonment, negligence, duty of care. Does an employer have a duty of care to you as an employee?
Yes.
Yes, they have a duty of care to you as an employee, okay? And that could be things like the duty of care could be health and safety, could be that you wear the right equipment if you're working with, you know, infectious like elements, you know, any sort of PPE, hard hat, things like that. The neighbouring test is a part of tort, is a principle laid down in this really important case of Donoghue and Stevenson, and it provided the foundation for the development of the law of negligence in the 20th century. So the facts of the case were concerned two friends who visited a cafe, only for one of them to discover a decomposed snail in a bottle of ginger beer purchased by the other. And the importance of the decision ultimately, which was handed down by the House of Lords, was that they discussed the boundaries of a duty of care in negligence. So, you know, the whole point of this was the neighbouring test was identified, and it was identified that that you must take reasonable care to avoid any sort of acts or omissions which can reasonably foresee would be likely to injure your neighbour. So the neighbouring test in this opened the doors for claims in negligence. So at this time in the 20th century, they opened so many claims for negligence in regards to this element. So it's and some of the cases were false cases, but because the law was open, the courts opened the doors, then this case was the main case that was using. So the next one is 1M1. So this is the merit one. So if you want to, when it comes to your assignment, do this part of it. This is the merit one. So it looks at identifying, assessing the validity of given contracts. And the famous case of this was the case of Felt, House and Bindley in 1863. So the claimant was interested in buying a horse at that time, and it discussed this with his nephew. Of a horse belonging to him. The claimant wrote to his nephew and stated that this letter that he assumed the horse was his for £30 and 15p if he did not receive a response from his nephew. The nephew did not reply and instructed the defendant, an auctioneer he had engaged to conduct a sale of his farming stock, to withhold the horse from the auction. By mistake, the defendant allowed the horse to be put up and sold. The claimant sued the defendant for damages, and it was held in court that an acceptance of offer will not give rise to a binding agreement unless it is expressly communicated. The individual who makes the offer, although the nephew, to sell his property, he did not communicate the intention to his uncle or anything else. Since property was not vested in the claimant, he had no right to bring an action. And that was the element of the postal rule and why it's so important in regards to a contract. Another important case is the case of Adam and Sinsley, Linsell, which you can have a look at in your own time because we haven't got long actually to finish the session. So I want to try and get through all this, okay? The elements, the next one is 1D1, which looks at shareholders and auditors, and why they are so important in regards to elements of, you know, an agency relationship. When we look at shareholders, they are agents as well. They are regarded as agents. Okay. Who are auditors? What do auditors do?
They verify your financial statement.
Excellent. They verify your financial status. Okay, so they are shareholders are the legal owners, okay,
Yeah.
of the corporation and own shares in the company's share capital or stock. There's no direct interaction between shareholders and auditors, and because, you know, shareholders have control over auditors as they're paid to audit the company. So like you said, is there need to have auditors, Nisa? Why is it so important?
Because like people rely on the financial data and it
Yeah.
needs to be verified by a third party.
Yeah. So they are like the watchdog.
Correct.
Ensure
Yes.
any
Yeah,
sort of financial statements, any sort of management reflect the financial performance of that business. So, you know, there's a need for them. Next one is the cost of agency relationships. So agency costs arise largely from principals monitoring activities of the agent. So it's all to do with the principal. The principal is the one who bears the cost of everything. And the principal is the main one that the agent refers to if there's any sort of issues or if there's any sort of elements of it. So they look at the costs of management, the cost of the meetings. The next one is residual loss. And this is an additional type of agency cost and relates to directors furnishing themselves with expensive cars and phones. These costs are above and beyond the remuneration package for directors and a direct loss to shareholders. If the market and shareholder activities are not enough to monitor the company, then some form of regulation is needed. And the shareholders will decide if anything is being done that is breaching any sort of, you know, issues around it, they will take account of it. Examples of codes of conduct include the UK Corporate Governance 2010 and the Corporate Governance adopted by the Financial Services Authority, FSA, which you can look at in your own time, the OECD Code of Ethics, and ACCA codes. So we've looked at the elements of a contract, we looked at the issue in regards to contracts, and we've looked at tort law, contract law, agency and principle, and there's some further reading on Moodle as well if you get onto Moodle. I've also linked an elements of contract there as well for further reading, and a book there by Business Law by Keenan and Riches, which is quite a good book to read, and it's quite an easy book for you to have a look at. And there's some other elements of additional sources and additional reading that you can go on to. And on Moodle, they'll have some additional sources that you can refer to. If you have any questions, feel free to ask. Anyone got any questions? I think someone share your handout. Thank you. Handout, what do you mean, Jane? Hello, Jane. Hi, can you hear me, Jane? Oh, can you not see the PowerPoints? Nisa, can you see the PowerPoints?
I can see the PowerPoint. Yeah.
Yeah. I think I cannot talk as okay. The PowerPoints are all available on Moodle, okay, for you. Is the size too small? Can you not see the size? Let me just try to increase that.
Yeah, at the bottom. Yeah.
Yeah, so the notes and everything are available on Moodle for you. The slides are on Moodle with the notes and everything on. If there's any sort of additional reading or anything, they're all available on Moodle. And if you have issues accessing Moodle, okay, you need to be emailing learnerwork@ukvarsity.co.uk if you have any issues accessing Moodle. Does everyone have access to Moodle? What I'll do is I'll email the office as well and tell them that you not need access to Moodle, but you also need to email learnerwork@ukvarsity.co.uk any sort of issues you have, any sort of elements of that. You also need to you know, when it comes to your assignment, you need to email learnerwork@ukvarsity.co.uk. That's once all the learning outcomes are done. So once all the learning outcomes are finished, then we'll have an assignment discussion. If you have any questions around that, you could email me, talk to me around it. And if you have any questions around how to submit your assignment, things like that, you could email LearnerWorks. These are the references we've used for today's session that you can go on to, and the links. And there's also a Kahoot contract law quiz there that you could go on to as well if you just copy and paste that link into your main link. Has anyone got any questions before we finish today's session off?
No questions from my side. Thank you.
Are you sure? Anyone else got?
No question. It's just what I would ask is your contact detail just in case we want to reach out. I want to reach out for a
Okay.
question.
Yeah. What my email is, it's just I'll just put it in. Shall I just put it in the chat for you?
Yes, please. Thank you.
It's okay. Shazia at, I've forgotten my email address. Shazia at ukvarsity.co.uk. So this is my email address if you have any questions or anything. But you'll see me tomorrow's session because we've got another session tomorrow on Learning Outcome 2.
Okay.
Okay. So
Yeah.
I'll see you tomorrow. It's at 10 o'clock tomorrow. And I will see. Has anyone else got any questions or anything? Jane, what I'll do is if you send me an email, I'll send you the slides via email as well, okay? But just send me an email. I can't attach it to this chat because I think it just doesn't. But can you send me an email? My email's just there. If you send me an email, I'll respond to your email. I think it's
I can't see.
Shazia.
I
Sorry?
can't see your email. I cannot see your email.
I've put it in the chat. Is it not coming in the chat?
No.
It's Shazia, 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 Shazia at ukvarsity.co.uk. Yes, thank you, Jane.
Thank you.
Thank you. So if you have any questions or anything, just email me then. Has anyone got any questions now before we finish off? Anything else? If not, thank you, everyone. And it was lovely meeting you all. Thank you for attending today's session. And I will see you tomorrow at 10 o'clock for Learning Outcome 2.
Thank you.
Yeah.
Thank you, Shazia.
Thank you.
Thank
Take
you.
care. Bye. Have a
Bye.
good weekend. Well, you've got tomorrow to see me anyway. See you later. Bye.
Thank
Bye.
you.
Bye.
Bye-bye. Bye.
Take care. Bye.